I'd be on my private island in the Caribbean, right? You know, so, but markets have the ability to solve problems in ways we can't anticipate today, and we just need to unleash them on this market.
There's a question now.
John Kenese, Energy Policy Counsel. We had a tiny window into Aramco. We wanted to issue orange markets of ownership on Summit. But this is the question about Saudi Arabia's delayed intention to issue a partial IPO, which would increase accountability, et cetera. If that ever occurs, how do you see Saudi Arabia's involvement with OPEC? Does it change at all? Increased, some honest increased transparency, et cetera.
I mean, I'll start. I think Saudi Arabia will try to keep the best of both worlds, right? Limited, offering no loss of control, and keep OPEC. That would be my strategy if I were Saudi Arabia. But it's not a good strategy for the United States. I think it's the rest of the world.
At the time that the IPO started to surface, there were some reports that one of the concerns that Saudi Aramco had was that it increased their antitrust risk. I'm actually not certain that that's true legally, but because they still weren't going, they'd still be a state-owned enterprise, they weren't getting that much control. But in the sense of maybe raising their visibility, it seems to me stories that say that it's more profitable, that Saudi Aramco is more profitable than Apple, does raise their visibility, particularly in in an antitrust community that has discovered that we should be concerned about big companies. Final point on the bill, just the bill only covers collusion. So even if you broke up, OPEC and that agreement, Saudi Arabia and Aramco would still be a very powerful company. And whether they would be powerful enough to be caught by the monopolization provision of the antitrust laws, I don't know. We need to look at that more closely. But this bill doesn't really deal with that. On its own, Saudi Arabia would still be pretty powerful.
For a second, Andy, you were talking before about sort of this dual hat that Saudi Arabia likes to hold. I'm a sovereign, or I have a public company, and I guess a bond issue. Why don't you share your thoughts on that?
Yeah, so in some sense, right, the Saudis want to have it both ways, or not just the Saudis, all the members of OPEC, right? Sometimes they want to be a company, and they want to have the advantage of going to capital markets and raising money and so forth. And sometimes they want to say, oh no, I'm a government, you can't interfere. They have chosen to enter the marketplace and be economic actors. And so they should play by the same rules as everybody else. So if a government wants to sit back and just levy a tax and so forth, that's governmental action, and we appropriately do not try to extend U.S. law to cover that. But treating OPEC countries, when they enter the marketplace, as market actors, whether they're wearing their Saudi Aramco hat or their Saudi government hat, as suits them, I think it violates this sort of fundamental idea of an equal playing field, a level playing field for all market actors. That's how markets are supposed to work. That's why we have antitrust laws.
Question there, and then you'll be next.
Stephen Cunningham from Bloomberg. I just wanted to ask Robbie, how confident are you that NOPEC will make progress in the current Congress, given the House Majority Leader said yesterday that NOPEC wasn't on his radar?
Yeah, so, not being on his radar, we just have to put it on his radar. I would say that, as you heard from Seth before, the truth is that it's had a veto-proof majority in both the House and the Senate. You just have to get it to the floor. And I think that the more transparency there is, just as we want the oil markets to have transparency, we would like this process to have transparency in itself. Because people should have to stand up and defend a cartel. It is amazing that the Chamber of Commerce that defends free markets everywhere is one that's willing to stand up against the operation of free markets. I think on drugs, they're running commercials today talking about how we shouldn't let cartels, other countries determine, price on drugs. Well, why are we letting them determine on the most important commodity in our economy? So my view is there's clear support amongst a majority of Americans for sure, clear support amongst a majority of House and Senate members, and the President of the United States has boldly written about it in his prescient book in 2011, To Make America Great. And we're in that process, and this is one of those pieces to complete his promise to do that. So I think it's just having to get it to the floor, and this will be one of those things where maybe we'll all say, wow, we can work in a bipartisan fashion.
Thanks very much. Rachel Zamba, Center for New American Security at New York University. I wanted to dig a little deeper into how this tool might actually be used. I totally take your point that the threat of it existing, and I mean, there's so many different permutations within OPEC, but just drawing on the antitrust expertise and past examples, how might you see the Department of Justice, and I know Admiral Blair has already highlighted how it might be part of a broader strategy, but I'm thinking more on the kind of the legal process. What might this, because it strikes me that as this bill comes to effect, that might be the type of questions we hear more of. And I recognize that this is probably a very long question and longer discussion, so thank you.
It's a great question. And did you say New York University? It's a wonderful place.
Yeah.
Okay.
There's a political economy there where we actually deal with institutions.
I teach at New York University, so but it's, I'm not plugging a book, just the university. Okay. So I don't know exactly what choices would be made for this statute, but sort of in general, if we put this in the context of how international cartels are dealt with, international price fixing agreements, they are viewed, first of all, as criminal. The Justice Department has a very effective tool for getting information about cartels and being able to prosecute them. It's very nice that we have studies and there are articles in the New York Times and all that. That's not evidence. So the government has to get documents. They've got to focus on which companies do what, how what decisions are made, and who makes them. So that tool is amnesty or leniency. And the basics of it is the first party that comes through the door to the Justice Department and says, I'm going to cooperate, not fight, is the one who gets amnesty. They're not prosecuted. So my hope would be is that if it's seriously communicated that the Justice Department is looking at it this way, there would be a number of lawyers in this city who will be saying to their clients, get your marker in first, so you get off, and help, and that means you'll help the government. And what makes this even more interesting is the hesitancy in other cases is that they then face private, civil, treble damages cases, but they don't hear. So in this case, as you think about it, that might be a very effective tool for actually prying out exactly what happens, who did what, and gives tremendous incentives to be first in the door. Second and third also get better treatment, and they may find, and we may find, that this is about more than just a decision about output. It may be a decision about who gets access to markets, who gets rights. I don't know, because in fact this industry hasn't been investigated in this way. So I think that's a very important aspect of what could happen. The Justice Department could also proceed civilly. They won't have that amnesty tool, and the remedy will be, don't do it anymore. Sin no more injunction. Less effective, but I don't know whether they'll take it back or not. I have no idea. But those are the two basic routes. And as I said, that this is, if there is a green light to the head of the Antitrust Division to go ahead with this, it can be regularized in that sense. And there has been built up over the past 2 decades a great track record of how you deal with international cartels. This is not new work for the Justice Department, just defendants that they have not had the opportunity to look at.
And then does that generally lead to negotiation, or you actually go to the point of seizing assets? And,
Well, you can't, this is a great point because there's a difference between the civil and criminal. So in the criminal case, people have to be tried first. So we usually don't try people in absentia, thank God, for us. So you have to get a hold of someone. The seizing of assets, if at some point people don't pay the fines or companies don't pay the fines, I guess the Justice Department is going to look at that. But the track record, and there have been some very large fines. We're talking fines between $500 million and $1 billion. In past cases, you can see a list of fines in excess of $100 million on the Justice Department's website. And there hasn't been that problem of collecting. Now, would there be a negotiation? As in every criminal case, most firms and most people do not go to trial. Some do. So, in that sense, yes. The Lysine Cartel, go watch The Informant. There aren't that many antitrust movies. That's what I always tell my students. Make sure you see it's not been something for Hollywood. But who played? Yeah. Actually, I once saw a panel where the person who played the FBI agent came, and it was fun. Anyway, the worry about seizure of assets really is an aspect of private civil litigation where you can get default judgments and go after assets in the United States. That's not this case. There will, the chances of there being an agreement on what sort of fine there might be, that may be possible. And the possibility of, what do you do with the individuals? That also would be a matter for negotiation as it is in international cartels. You should be aware that today, I don't know the exact number, there is a non-insubstantial number of foreign citizens sitting in U.S. prisons for fixing prices. And their governments haven't gone to the mat about this, they've accepted it. So, I don't know what's going to happen, I don't know where this would go. It's, but the tools are, they're real tools.
Can I just expand on that a little bit? And I agree with most of what you heard you say, but I do have a couple of differences. One is on the question of evidence. Sure, the leniency program is great, and companies can come in and invest, but a lot of what OPEC does is open to the public. It's clear. They agree, they make public statements about the price cutbacks, and there isn't a mystery about that. So maybe if you get into the question of who's exporting and the roles of private companies, you need evidence. But if you just want to go after nations that are part of an oil cartel, I don't think you need much investigation. It's pretty clear what's out there. I also have a little bit of a difference with Harry, and this gets into the technical antitrust law, which you don't need to discuss. I think it is possible under civil antitrust. The government can go as a purchaser of oil. Obviously, the military purchases a tremendous amount of oil for jet fuel and other things, to go and seek treble damages on a civil remedy. There's some technical issues about that, but I think, and if they did that, then they could seize assets if they were successful. Because a lot of these nations and private or state-owned oil companies have substantial assets in the United States. So that's another thing that could happen. But as I said earlier, and I think as you were saying, I think the real theory of NOPEC is you never have to go to court to enforce it. You make it part of a negotiation. And you say, we're just reading in the press about how the plans are to cut back 10 million barrels a day. This is running contrary to our antitrust law. Now, we'd rather not have to bring you into court in the United States. Is there something you can do here to make this go away? Just to cut it out. Don't engage in this behavior. Just as Russia decided not to join OPEC, without even OPEC being enacted, just as the threat of it being introduced in Congress. I think the fact that it's out there and it's a tool that the Justice Department can use in conjunction with the State Department and other parts of the executive branch, we don't have to get into legal technicalities. I just think that's an important part of the way that OPEC would work.
I just say, as we go around the world asking for people to pay their fair share of our military expenses, this should be something our military should say to them. Why should we be spending that $81 billion for free? You should be paying us for that. That sounds like something President Trump could like.
I prefer they provided ships to be part of our battle groups, but anyway.
Okay, last question, and then.
It's actually two questions, but they're very quick, or one's quick anyway. The first question is probably for the Antitrust guys. Did the U.S. government or was there any sense of acting against OPEC's predecessor, the Texas Railroad Commission, when it was in charge of oil prices? It was just a historical question. I'm just ignorant.
Well, obviously, I'm not ignorant. You're asking a question beyond my knowledge. So I have no idea, but I would doubt it.
Okay, let me ask you.
I can.
Oh, okay.
So the Texas Railroad Commission, the efforts to control the price of oil, that has roots in the federal government, and so in the New Deal era idea that cartels were good. Okay. And so that, they were promoting domestic energy cartels.
So I'll circle back to that. This was part. I don't remember the Texas. These were federal officials. This was part of the Subcommittee vacuum case in 1940. Part of the Subcommittee vacuum case in 1940, where it was a sort of a hangover from the New Deal, where the government was involved with the industry groups and sort of maintaining and fixing up output. And the Supreme Court said very clearly that the federal officials were virtual volunteers. They were not told to do this by Congress. There was no exemption, and it was not a defense to the oil companies that tried to raise it. Well, it was approved by the government. So in that sense, it did play in that case. But, I don't know about suing at a stage.
I just want to say one thing to that, which is, I'm definitely for the fair and free market and allow transparency and price discovery, which I think would go a long way. But let's assume that we say that oil has always needed a market manager. We had Standard Oil, then we had the Texas Railroad Commission, then the United States allowed OPEC to exist. Well, the question today is, well, then why shouldn't we be the market manager, especially with the oil that we have? And look, some of them are great ideas, some of them might be crazy, but we have a Federal Reserve. Could there be an independent? We could actually create the infrastructure for shale production, but not turn it on. And someone could, manage that independent. I'm not advocating for those decisions, but I'm certainly saying the idea that there be a market manager, and even if you accept that idea for oil, which I don't, then the question is, well, let's at least figure out how we can be that market manager with our SPRO or other things. I don't think we'll do a good job at it. But I just do not understand the idea that we should let someone else who doesn't necessarily share our values or our interests be the ones to make those decisions. And I think we stop with the questions. If people have specific questions, why don't you come up here? But thank you very much for coming. Thank you all. That was really fascinating. I really enjoyed it. Thank you. And we'll be soon again at 7:30. No, I'm just joking.
No, this was actually here for the federal conference. So actually, mentioned that.